Content creator Mary Ann Lorient has presented a highly specific, concrete claim. She received a $68,600 settlement check following a dispute with Dr. Umar Johnson. She describes the payment as the direct result of a federal investigation, framing it as reimbursement for therapy, hardship, and financial losses incurred during a film production. In the modern digital ecosystem, the assertion of a legal victory is frequently accepted by audiences as absolute proof. High dollar amounts carry a weight of legitimacy that often discourages further questioning. However, a claim of this magnitude leaves an unavoidable trail. If a $68,600 federal settlement occurred, it must align with established legal and financial procedures. We can test the validity of this narrative by applying the standard financial forensics used by U.S. institutions to verify the movement of high-value funds. This grid maps the criteria required to validate her account: jurisdiction, public records, banking compliance, and settlement logic. The integrity of the story relies on all four quadrants. If a single requirement remains unmet, the narrative of a secret federal payout collapses. We are testing this specific financial claim against the rigid procedural laws of the United States. The federal court system serves as the starting point. It maintains an exceptionally high barrier to entry for private civil disputes. For a private civil matter to enter the federal system, it generally must qualify under diversity jurisdiction. This occurs when the parties involved reside in different states, and the financial stakes meet a specific legal minimum. Federal law dictates a rigid amount in controversy requirement. Damages in these cases must exceed $75,000 to be heard in a federal courtroom. Lorient's claimed settlement of $68,600 sits noticeably below this threshold. This specific dollar amount is mathematically insufficient to trigger federal mechanisms. A federal court would lack the authority to preside over a private claim for that sum. If the dispute were instead handled in a local or state court, it would not involve a federal investigation, which contradicts the central premise of Lorient's account. The figure chosen to legitimize the story is the same figure that proves the federal court system could not have been involved. This leads to the secondary claim that federal entities investigated Umar Johnson and negotiated this payout directly to a private citizen. Agencies like the Department of Justice or the IRS enforce federal law on behalf of the government. They do not act as intermediaries to facilitate private settlement checks for social media critics. When the government recovers funds from financial irregularities, the money is distributed through a formal remission process. These funds are managed by government administrators, not through private checks from the target of an investigation. A private citizen might benefit from a federal fraud investigation through a qui tam lawsuit, a provision of the False Claims Act. In these instances, a whistleblower sues on behalf of the government to recover misappropriated funds. Under the law, once a qui tam suit is unsealed or resolved, it must generate a permanent public case file. We can verify this through the PACER system, the Public Access to Court Electronic Records. PACER is the definitive ledger for all federal litigation in the United States. Searches for federal civil filings between these specific parties return 0 results. No federal agency case numbers, official correspondence, or court orders of dismissal have ever been provided to support the claim. Federal litigation does not occur in secret. If it is not in the public record, it did not happen. We must also address the physical claim. Lorient asserts she is in possession of a $68,600 check. Despite her active presence on her YouTube community tab, where she has shared details of the alleged legal meeting, no image of a cleared bank check or a deposit receipt has been produced. The Bank Secrecy Act and anti-money laundering regulations require financial institutions to verify the source of large domestic deposits. Depositing nearly $70,000 requires a bank to collect and verify documentation explaining the origin of the funds. A bank would mandate a formal settlement statement or an attorney's closing statement to clear the deposit, documents that are entirely absent from Lorient's public record. Furthermore, a payment for hardship or lost income would require the issuance of a Form 1099 MISC for tax reporting purposes. No such record has been disclosed. Text-based social media posts are being used here as a substitute for the mandatory banking documentation that would exist if the payout were real. Beyond the data, we must look at behavioral logic. We have to consider why a defendant would agree to a high-value private settlement. Private resolutions of this size are built on two mandatory clauses: non-disparagement and confidentiality. A defendant pays a large sum specifically to end a dispute and prevent further damage to their reputation. The money is legally tied to the claimant's silence. Lorient's behavior directly contradicts this legal standard. She continues to upload videos openly discussing the payout and criticizing the other party. In a real settlement, these public broadcasts would constitute a breach of contract. This would allow the defendant to immediately halt payment or claw back the funds. Her continued public commentary is the strongest behavioral evidence that no binding confidentiality agreement or settlement check actually exists. The narrative fails to meet any of the necessary legal or financial criteria. It falls below the jurisdictional threshold, lacks PACER documentation, violates banking regulations, and contradicts the logic of a legal settlement. A forensic examination confirms that the claim of a $68,600 federal settlement is a digital fiction unsupported by institutional reality. This type of misinformation has a corrosive effect on the community. Fabricating the involvement of federal agencies erodes public trust. It makes it significantly harder for genuine victims of financial misconduct to seek justice. The complexity of the legal system is often weaponized by content creators to manufacture credibility and drive engagement, banking on the audience's unfamiliarity with federal procedure. True institutional and financial accountability requires more than a headline. In the federal system, social media assertions are never a substitute for the public record.